Both counsel are present, and we sent out a focus letter in this case of some issues that we wanted to raise. And but first of all, just to indicate for observers that this case comes to us on a writ petition concerning the extent of time to examine a dying mesothelioma plaintiff under CCP section 2025.295. Mr. Hugo, you may proceed.
Thank you, Justice Needham. The answer to your first question is yes, but only if 2025.420 was not nullified by 2025.295.
Just to make sure I understand that argument, you're saying that if 420 does not by itself create a power to authorize additional deposition time in excess of limits, you would concede that 0.295 on its face has a hard cap of 14 hours. Is that right?
Yes.
Okay.
And the answer to question number 2 is yes, because 2025.420 was not nullified by 2025.295. The evidence of that is the first 3 words of 2025.295. Those 3 words are notwithstanding section 2025.290. So let me be clear for context. 2025.290 and 2025.420 were both effective in 2013. In 2019, when the legislature was considering Bill SB 645, they were not only aware of the existence of both statutes, they were aware of the effect of both statutes.
And when you say they were aware of both statutes, and I'm just going to refer to it as 290 rather than 2025.290 because that's a mouthful. But 290 subdivision C had what I will describe as a savings clause, in which subdivision C said it is not the intent of the legislature in enacting 290 to impact a party's ability to get a protective order, presumably referring to 420. But 295 doesn't contain that language. What importance should we place on the fact that unlike 290, 295 says nothing about you can still go get a protective order?
First of all, I agree with you. You are correct with regard to 2025.290. However, 2025.295 contains these first 3 words, notwithstanding. And the second 2 words are section 2025.290.
Right, but one part of 290 was the savings clause referring to protective orders. So even using your argument, the first 3 words of notwithstanding section 2025.290, that would include the subdivision C of 290, in which the legislature expressed or specifically disclaimed any intent to impact a party's efforts or ability to get a protective order.
You are 100% correct. What I'm conveying is slightly different. When they say notwithstanding section, they do not include 2025.420. If they wanted to nullify 2025.420, they should have said notwithstanding sections 2025.290 and section 2025.420, and then continued their discussion regarding the hard cap time limits on mesothelioma plaintiff depositions. By omitting 2025.420 from the notwithstanding, they did not nullify it. They knew about it, they could have, but they didn't.
So, Mr. Hugo, let's assume that that argument is correct. What is the best argument or case citation that you have that 420 would support a trial court's power to award additional deposition time in excess of statutorily enacted limits? Is there a case?
The statute itself. The words of the statute allow the court before, during, or after a deposition, and then it goes on to provide the powers. There's nothing in there that talks about not limiting or limiting the time. It's to do justice, which the trial court is in the best position to do.
Is there a statutory provision in 420 that explicitly grants the power to award excess deposition time?
I don't believe that the word excess is in there, but it grants the trial court the power to do justice with regard to, and we're talking fairness and decency with regard to the deposition. And it's neither fair nor decent to provide on average less than 10 minutes, which you've given me, to each defendant in a multi-million-dollar personal injury products liability action. And let me give you an example that makes this even clearer. I think you're all presuming that the majority of the defendants have any deposition time under 2025.295. That's not necessarily true. Who controls the number of defendants and when they're brought into the case? It's the plaintiff attorney. So pick the same group that we have, in other words, the same defendants in this case and the same plaintiff. And we're going to change one thing, the sequence in which they were brought in. So we're going to have 21 defendants named in the original complaint. They take the plaintiff's deposition. The plaintiff attorney enforces the hard cap of 14 hours. The trial judge says, I don't have discretion. It's 14 hours. The deposition concludes. The next day, the plaintiff amends the complaint and brings in the other 80-plus defendants from my case. How much time do they have in the plaintiff's deposition? None. Zero, zip, not in none, because the 14 hours has been exhausted.
Can we return for a moment to the legislature's intent? So in the legislative history, the Senate Judiciary Committee created a bill analysis of the bill that enacted .295. And on page 2 of that bill analysis, they acknowledge the existence of .420. So they know that it's out there, but they nonetheless describe this bill as, and I'm quoting, providing a clear cap on the length of depositions of plaintiffs. And on the last page of the bill analysis, they go on to say, this bill places a tight limit on the length of deposition testimony, affording courts discretion only to extend to a total of the provided for limit. Doesn't that make it pretty clear that what the legislature had in mind here was a hard cap with no exceptions for 420 or 295 or any other reason?
It appears that they were going for that. Whether or not in the grand scheme of compromise, that's what 2025.295 actually says is up for debate. However, if your reading is correct, then we get to question number 3, and the compelling answer is that 2025.295 violates fundamental decency and fundamental fairness, because it imposes unilaterally time caps on only defendants. The plaintiff attorney is the one who controls the sequencing of the defendants, the number of defendants, and there is no relief under your interpretation of the statute. That's the only statute in the United States that I'm aware of that has those constraints with only one party controlling the constraints. That's fundamentally unfair.
Mr. Hugo, I just want to make sure I understand your position. You are no longer making a facial challenge. You concede that this would survive a facial challenge. Is that right?
Since I have 10 minutes, the answer is yes. Okay. And the only twist on that I want to point out is it's an interesting situation when the facial challenge, as opposed to an applied challenge, has one common element. And the common element is that the plaintiff is controlling it. So it is both on its face and the application of it, both are unconstitutional. But for the purposes of our discussion, yes, I'm conceding that it will pass a facial challenge.
And you're not arguing that the trial court abused its discretion in denying a protective order under the facts here, is that right?
Well, we have 2 trial courts.
Judge Markman, when Judge Markman denied the protective order, you are not in this writ appealing from that denial of the protective order. Is that right?
No.
Okay, so I just have one last question. I know I've had a lot of questions for you, and I apologize. So one last one.
I like questions.
Why isn't Judge Markman's findings in denying the protective order fatal to your as-applied challenge, to the extent that he is saying that as applied to this class of defendants And given the deposition of the plaintiffs here, the 14-hour cap did not operate to violate fundamental principles of fairness and decency because you had sufficient time to cover lots of ground. There's a common strategy. Why aren't his historical facts fatal to your as-applied challenge?
Because he certified this to determine two things. One, whether or not he had the discretion to extend it, and two, what factors he should consider. The second part of his decision invites you to tell him what to look at when this case is remanded back to him. And we're requesting, in fact, that both of the orders be set aside, that this court find that 2025.295 is unconstitutional, or that 2025.420 applies and he has discretion, and you can tell him what to look for. For example, the number of defendants is relevant, the time period in which the plaintiff worked is relevant, his occupation, his employers, whether OSHA is applicable. There are a lot of factors that could be considered. Judge Markman did not consider all those factors because he didn't know which factors to consider and whether or not he had the discretion to do so.
Mr. Hugo.
But you had an opportunity to bring all those issues up in front of him, didn't you?
Yes.
And you didn't?
No. We brought as many issues as we could to him, but he's...
All the other additional factors that you just mentioned that he didn't go through, you didn't bring those up at the time, right?
No, we brought up as much as we could in terms of the subjects covered at the deposition, which include plaintiff work history, the number of years, the number of occupations, etc. Right. But he didn't have the filter to look at all of them or consider them because he didn't know whether he had, first, right, the jurisdiction and the ability to do so, and second, which factors to look at.
Okay, let me ask you this. Do you have any support that we should not consider the one of the standards of statutory construction is that section 2025.295 would take precedence over section 2025.420 as a more specific statute that was enacted later in time?
It was enacted later in time, and I'm relying on the exact words of 2025.295 to prove to you that 2025.420 was saved and not nullified. It is specific, and they specifically omitted nullifying 2025.420 in both section A and let me point out, in section B as well. Section B starts out with this exact same word, notwithstanding, and then it does not include 2025.420. If the legislator wanted to nullify it as to only 2025.295, they had the opportunity to do so. They had the knowledge that 2025.420 existed, and they had the knowledge of the effect of 2025.420.
One more thing, I think Justice Burns has a question. It's my understanding this went through a real, one of the best, the legislative history and in this case seems to be very thorough. The Civil Justice Association of California participated, the California Defense Council participated, and I know you and your firm participated. And throughout this process, the court made this very limited legislation for a particular type of plaintiff. They recognized the ability of cross-examination, and they also recognize alternative tools or devices, discovery devices to get information to. And so it was kind of like a balancing act, which I don't think you would agree with. But they also went through they tried to compromise this thing too. And so they added like the 10-day, went from the 10, they went to the up to 10 days. They made the amend. They had added two amendments: the one with the 10 and the one with the 20. Okay. Then after they did that, it's my understanding that these particular groups, the Civil Justice Association of California, the California Defense Council, withdrew their objections to the bill. Is that correct?
Yes.
Yeah. Thank you.
And compromise is what brought us the Pontiac Aztec. In other words, it's not always something that ends in a good result. And in this case, it didn't end in a good result. There's no indication that the legislature ever considered the fact that there'd be over 100 defendants brought into a case. There's never any consideration of the legislature that this whole statute could be gamed by a plaintiff attorney in terms of bringing in clients in different times and using up all the deposition time before many of the defendants even showed up. When you look at the statute, what exists after the fact of the compromise, it's unconstitutional.
Okay. You've used up your time, but Justice Burns has some questions, and please proceed, Justice Burns.
I just have one question. Why should we reach your as-applied due process challenge now on a writ? There is a lot of information that could be relevant to determining whether or not, as applied to any particular defendant, the cap on the deposition is fair. You could come up with all kinds of impeachment evidence, very effective impeachment evidence in discovery. At trial, Mr. Richards may testify. The depo may never come in. He could be cross-examined very effectively. How is it we can now say that this is unfair fundamentally?
You waited once, which was to allow the deposition to occur. We've now taken the deposition, and you see that you have 100 defendants trying to cross-examine someone who may be the only witness about the facts at issue. This isn't a case where there's a car accident yesterday and there's a couple drivers. It's not just his credibility.
Isn't the key word maybe the only witness? I mean, we don't know. We don't know what other information defendants may come up with that are important to them in this case, or how those facts will play out at trial. So it's really odd to be sitting here now and trying to predict that this was unfair as to any particular defendant when it may not be, because they come up with great impeachment, or maybe they get, a non-suit because the plaintiffs really don't put on a case against them.
Well, what they're not going to get is a motion for summary judgment granted because they didn't have enough time to cross-examine them. So the irreparable harm is having 100 defendants with each less than 10 minutes on average to cross-examine someone in a multi-million-dollar personal injury action.
I'm not sure we could say that you wouldn't even have enough for a motion for summary judgment. I mean, we still don't know what you're going to come up with at trial. In discovery.
Well, there's going to be a question of fact because Mr. Richards was allowed to testify with minimal cross-examination.
Okay. Any other questions? Okay, Mr. Hugo, you used up your time, but that's okay. You used somewhere between 18 and 20 minutes. Mr. Hugo, I will give you 1 more minute to in rebuttal.
Thank you. I'll make 2 points. As Justice Rodriguez pointed out, you can't reset the clock unless the trial court has the discretion to go in there and do it. So he conceded that the trial court does have the discretion. 420 provides the court for good cause shown may make any order that justice requires to protect any party. That is the language that works here. Second and last point is Mr. Fishback indicated that there are other remedies. The trial courts need guidelines from you as to what they can do, both in terms of regulating the deposition time, and if they can't, what they can do for other remedies. That's what trial courts are looking for from you in this case. And I'm asking you to provide that information with this case.
But you know what, Mr. Hugo, it's I appreciate your comments, but we stepped out of the trial court, at least for me, a long time ago. And I think Judge Markman is in the best position to hammer out solutions based on the law. I appreciate the opportunity, though.
Thank you.
Good.